Welcome to Printing Industry Midwest, and we are presenting a webinar today on earned safe and sick time laws and other items. We have Tom Revnew, who is on our PIM board of directors, as well as an attorney at Littler. Longtime member of PIM, and has provided a lot of expertise along the way. And we're going to get him started on a very important topic, and I want him to have the full time available. So thank you, Tom. Oh, wait, one more thing. If you do have questions, put them in the Q&A, and Tom will try to answer them as they come in. Also, though, he will leave time at the end to ask questions. We'll open up the speakers for anyone to have a question that they can ask them. All right. Thank you so much. Welcome, Tom.
Thanks, Chris, and thanks, PIM, for having me present today. And I'm going to spend most of my time talking about the upcoming Earned Safe and Sick Time law that's going to take effect as of January 1st. And I'm sure everyone on this webinar has been working actively to come into compliance or be prepared to be in compliance as of January 1st. I know there's still a lot of questions. I'm still fielding a lot of questions from clients. And so hopefully I can address some of them for you. And of course, with any new law, there's a lot of unknowns with regard to what the legislature intended or what have you. As Chris said, I'm Tom Revnew. I'm now with Littler Mendelsohn. I see a number of familiar faces on this webinar. I switched firms probably about 6 months ago at this point. So if you try to reach out to me and you've reached out to me in the past, just make sure you use my current email address. The prefix is the same as my old, so sometimes auto-populate messes things up, but happy to answer any questions that you may have, both during today's presentation or at any time in the future. So as Chris said, I'll talk about the statewide Earned Safe and Sick Time law that takes effect January 1st. And there's a couple other things that I'll talk about that take effect as of January 1st, just to make sure that it's on your radar. And one is the new law that bans employers from inquiring into an applicant's salary information. And then I'll just touch base briefly to remind all of you that there were changes that took effect as of July 1st relating to nursing mothers, parental leave, school leave. I'm still seeing some employers that haven't necessarily made the changes to their policies or procedures that they need to. And then very briefly, I'll touch base on the state-funded FMLA, but I'm really not going to say much other than to remind you that that's taking effect January 1st of 2026, and that's a different state mandate. Before I get started, I will say that I've been practicing labor and employment law for almost 30 years. And what happened in the last legislative session with all the changes in state law, I have never seen anything like it in my career. I know that there are quite a few employers that are pulling their hair out, so to speak, because of all these changes. And obviously I'm getting a lot of calls from clients and trying to help clients develop their policies and procedures so they can be compliant. And the one beyond the recreational marijuana, one of the big items that employers have been trying to sort out is what I'm talking about today, which is the Earned Sick and Safe Time law. And as everybody knows, this law takes effect January 1st. So we're about 30 days away from, a little over 30 days from having to be compliant with this law. And keep in mind that this law will apply or does apply to all employers. No matter how many employees you employ, you will be covered as an employer. And second, it covers all employees And so some of you who may have thought that it doesn't cover temporary employees or it doesn't cover part-time employees or seasonal employees, it does. And all employees will be eligible to accrue paid safe and sick time immediately upon hire, and they can use that earned safe and sick time after working for you for 80 hours in that year. From an accrual standpoint, I think everybody's probably familiar at this point that employees will earn 1 hour of earned safe and sick time for every 30 hours worked up to 48 hours in a year. And employees are allowed to carry over up to 80 hours unless you're paying out the unused leave at the end of the year. And I'll talk a little bit about how employers can structure their paid time off policies or their vacation policies or sick leave policies during today's session. But with regard to what employees can use the earned safe and sick time leave, it's pretty broad. Employees can use the paid safe and sick time for their own mental or physical illness, injury, or health condition, including for any medical appointments or preventative care. They can take the time off to care for a family member who is sick or needs to attend a doctor's appointment. They can take time off for absences related to domestic abuse, sexual assault, or stalking, provided that those absences are related to certain circumstances, such as the individual is seeking medical attention, or they're seeking services from a victim services organization, they're undergoing counseling, and what have you. Employees can also take earned safe and sick time due to closure of the employer's business due to weather or public emergency, or to care for a family member whose school or place of care has been closed due to weather or public emergency. And of course, because this law is taking effect January 1st, and in Minnesota, we oftentimes have school closures in January and February. We'll see the immediate impact of the earned safe and sick time pretty much right when it starts, provided the individuals have time that they can take off. Employees can also take time off due to their inability to work or telework because of health concerns related to the potential transmission of a communicable illness. So think, COVID is an example, right? COVID was related to a public emergency, or the employee is seeking or waiting for a diagnostic test of a communicable disease that is a public emergency. Again, think COVID as the example. And then finally, there's this catch-all where an employee can take time off if a healthcare provider determines that the employee's presence in the workplace would jeopardize the health of others because of exposure to a communicable disease. So employees can take this earned safe and sick time off for quite a few reasons. And of course, I think one of the things that employers will struggle with is employees will be able to take time off for family members who meet one of those criteria that I just talked about. And a family member is extremely broadly defined under the statute. And as you can see on this slide, it includes the children, foster children, adult children, legal wards, the child for whom the employee is the legal guardian, the spouses, registered spouse, sibling, step sibling, foster sibling, biological, adoptive, or foster parents, step parents, grandchildren, foster grandchildren, step grandchildren, grandparents, step grandparents, nieces, nephews, aunts, uncles, a child-in-law or sibling-in-law. And of course, this list is not over because it continues on, and it includes any of the family members listed above for an employee spouse or a registered domestic partner. It also includes any other individual related by blood or, and here's the kicker, whose close association with the employee is the equivalent of a family relationship. And I think we've all had scenarios where an employee comes to us and says, I need to take time off to care for my next door neighbor who is a close family relation, and my neighbor took care of me when I was a kid. And this law is broadly drafted that it could pick up somebody in that context. And then, of course, because the legislature didn't think we had broadly defined who a family member is, they also provided that employees will be eligible to designate one individual annually as a family member. And so they're going to have to, they can take time off for somebody that they want to classify as a family member during a year. So as you can see, with regard to the earned safe and sick time, employees will have the right to take time off, protected time off for a whole host of reasons, and they can take the time off when their family members need to take the time off for the protective reasons under the statute. As part of this law, you can draft a policy that requires employees to give you notice of the need to take time off. And keep in mind that as you draft your policies, if the employee is taking time off for a foreseeable reason, let's say they have a doctor's appointment and that doctor's appointment was scheduled 2 weeks out, you can have a written policy that provides that if the leave for ESST is foreseeable, you can require the employees to provide you with up to 7 days advance notice of the intention to use sick leave. However, if the leave is unforeseeable, and so think of a school closing, or think of perhaps somebody who wakes up with the flu, you can only require the employee to give you leave notice as soon as practical. If you are going to require employees to provide you with notice of the need to take time off for the reasons set forth under the Employee Safe and Sick Time Law, that has to be in a written policy. If it's not in the written policy, you cannot deny the use of sick leave as a result of their failure to give you advance notice. Perhaps one thing that I've been spending a lot of time with clients over the last, I would say in the last 6 months, is working with employers to come into compliance by making modifications to existing paid time off, vacation, or sick leave policies. And I will start with the caveat that the modern way of providing paid time off for employees is the adoption of a paid time off policy. I still see employers, however, who have a vacation policy, and that's it. And certainly the modern world has adopted the paid time off, which allows for more flexibility for the employees to take time off. But I see scenarios where clients have a vacation policy and they have a sick leave policy. What I would suggest is that if you have 2 banks of time off, of vacation and sick leave, I would be looking at combining those banks into one paid time off bank. But if you do have paid time off, you can make modifications to your paid time off policy that will bring you into compliance with the upcoming state law, provided that when you make those amendments, that the policy provides time off for the reasons allowed under the Employee Safe and Sick Time Law, and it meets or exceeds any of the legal requirements set forth under the law. Another common question that has been raised by clients is, do we have to accrue employee safe and sick time for overtime hours? And the answer is absolutely. The law was written that employees accrue time based upon all hours worked, not just based on regular hours. So they accrue paid time off based upon overtime hours worked. Additionally, with regard to salaried employees are presumed to work a 40-hour work week. And so that's what you would base the time on. As far as how you accrue for the employee safe and sick time is calculated at the same frequency as your other typical payroll practices. So it depends on how you pay, what your pay period looks like, whether it's a weekly or a biweekly or a monthly pay period. And then keep in mind that as you're working towards compliance with the new state law, you're going to want to make sure, particularly if you're working with a payroll vendor, and I think most of them are prepared to do this, that the amount of earned safe and sick time or your paid time off available, as well as the amount of time that has been used, it will need to be listed on the employee's earning statement. In other words, it needs to be listed on their pay stub. So you'll have to start putting that information on your pay stubs for employees going forward. As far as how employees accrue the earned safe and sick time, as an employer, you can set it as at a calendar year. You can do it on the employee's anniversary year. If you're on a tax year, you can do it that way as well. So one thing that I wanted to touch base with, and a lot of clients are trying to think through what makes the most sense as far as how do we get into compliance, but when you are considering updating your paid time off policies, you'll want to consider what makes sense, whether you front load the paid time off, the earned safe and sick time, or whether you allow for the carryover of the paid time off. So keep in mind that front loading is an alternative method to providing ESST accruals to employees. Obviously, front loading is just what it says. You essentially are recording the accrual of the employee safe and sick time once a year, and you can do it in a manner that you avoid carrying over hours from year to year. And some employers may want to use this method just to reduce the calculation and the record keeping requirements that are set forth by the accrual pay periods. So different options to consider. So the first is the accrual and carryover option. And this is an option where employees begin accruing the ESST from their first day of employment. The ESST accrues at a rate of at least 1 hour for every 30 hours worked. The employees are permitted to accrue a minimum of up to 48 hours of ESST in a year, but certainly they can accrue more if you as an employer agree to those higher amounts. And then employees can carry over the unused ESST into the next year. However, at no time can the employee's accrued ESST exceed 80 hours unless you as an employer agree. So just keep in mind that as you're looking at bringing your paid time off policies into compliance, you're going to want to make sure that your PTO policies are allowing for employees to accrue at least 1 hour for every 30 hours worked. And so that's going to be the first step in ensuring that you're complying with ESST. The second option where there's no carryover is you can front load the paid time off or the ESST up front. And so you essentially provide the employees with a minimum of 48 hours of earned safe and sick time or paid time off that you provide to the employee immediately, and it's made available for immediate use at the start of each year. And then the unused earned safe and sick time hours are paid out at the end of the accrual year at the employee's regular hourly rate. And then finally, the third option with regard to the front loading is you provide employees with a minimum of 80 hours of earned safe and sick time at the beginning of the year. And then you don't have to pay out the time at the end of the accrual year. And I'm seeing a lot of clients that are going to option 3, particularly when they're providing employees with at least 2 weeks of paid time off. But again, what you decide to do as an employer obviously is going to be something that has to make business sense for you. But there are different options that you can consider as you try to comply with the earned safe and sick time. Documentation. A lot of questions have been asked from clients with regard to, can we request documentation for employees for the need of earned safe and sick time? And the answer is generally no, you can't, unless certain exceptions come into play. And so you can request reasonable documentation for a leave that exceeds three consecutive days, and that reasonable documentation could be a signed statement from a doctor indicating the need for the use of earned sick time. But of course, if the employee says that they can't get a statement from the doctor within a reasonable period of time or without added expense, they can just provide you with a statement, a written statement that they took the time off for a certain reason. Additionally, when it comes to the care of a family member, the best you're going to be able to ask for is a written statement from the employee. And then if somebody's taking time off for safety leave, you could ask for a court record or a document from a victim services organization, maybe a police officer, an attorney, or a counselor provides some type of written statement. Just keep in mind that if somebody is taking time off for safety leave, you can't inquire into the reasons related to the domestic abuse or the sexual assault or the stalking. And in addition, you can't dive into the details of somebody's medical history. I think one thing that employers are going to struggle with as we adopt the earned safe and sick time in January is keeping in mind that this is time off that is protected time off, and employers are going to have to keep in mind that you can't retaliate against an employee for using the paid earned safe and sick time or requesting to use earned safe and sick time. And of course, I know that there are a number of employers that are concerned, and I think rightfully concerned, that there will be abuse by employees for the need for earned safe and sick time. And of course, when we do know employees are abusing taking time off where they claim they're sick when they're not, our immediate reaction is to do an investigation and take action as a result of the fraudulent behavior that employees are taking. And I'll just suggest to you that you're going to want to tread very lightly when you investigate claims of potential fraud for somebody taking paid time off when they shouldn't, because it is protected leave. And if you do take action against the individual, they will have a cause of action if they believe they were wrongfully terminated or even wrongfully disciplined. And so what I would suggest is, if you do face that issue, that you may want to confer with legal counsel just to make sure you're dotting your I's and crossing your T's to make sure you're addressing the issues that you need to. Other things to keep in mind with regard to the earned safe and sick time. A couple things are, one, you're going to have to issue a notice to the employees with regard to your policy, and that notice must be in English, and the employees have the right to request that that notice be provided to them in their primary native language. Your notice also has to give employees notice of their right to use earned safe and sick time. As I discussed earlier, you need to make sure that the employees earned sick time and the amount that they've used is contained in the earning statement or the payroll stub. Your notice needs to tell employees what the accrual year is, the terms of use, and that you provide the employees with a copy of your written policy that retaliation is prohibited. And also you have to build in to the notice that they have a right to file a complaint or bring a lawsuit if they feel that they've been retaliated against as a result of their use or inquiry into the use of earned safe and sick time. Now, the notice itself can be accomplished by posting. It can be accomplished by providing paper or electronic copies to the employers or through some web-based or app-based platform that employees are using. And then finally, I'm assuming everybody on this webinar has a handbook, and your handbook needs to provide a notice to employees as to their rights and remedies. With regard to the notice, and I'll touch base on this in a moment, but the Department of Labor and Industry has come up with a model notice that you can use to notify employees of their rights. That's on their website, and I'll touch base on that momentarily. A couple other things to keep in mind with regard to the earned safe and sick time. First of all, if an employee takes time off, the reasons for them using safe or sick time must be kept confidential. Many of you are familiar with the confidentiality requirements under the Americans with Disabilities Act when it comes to medical information. There's now a state law mandate that if somebody takes time off for safe and sick time, that information must be kept confidential. And so if you're documenting the reasons for somebody taking time off under the earned safe and sick time, you can't keep it in a personnel file. And this is a good time to remind you that there are certain things that don't belong in your personnel file. One of them is medical records. You should have a completely separate medical file. So medical records don't go into the personnel file. And then in addition, I still see this from time to time where employers put I-9s into somebody's personnel file, and I-9s should also be kept in a file separate from the personnel file. Things to just be aware of is that under the state law that was adopted, the state law will give grants to community organizations for outreach and education. And so employees will be educated with regard to their rights under the earned safe and sick time. I frankly think that some of these grants may also be used to encourage litigation against employers for violating, even if it's inadvertent violations of the earned safe and sick time. And if there are violations, just keep in mind that employees have 3 years to bring an action for any violations of the earned safe and sick time. So you may think that if an employee leaves after a year of being employed by you, that any claims under earned safe and sick time will be gone. But the law is clear that employees would have 3 years to bring action if you denied them or retaliated against them as a result of the use or request of using earned safe and sick time. I know that a number of you on this webinar probably have quite a few questions with regard to earned sick and safe time. And one thing that I would suggest that you do if you haven't is jump on the Department of Labor and Industry's website. They have a wealth of information on here. They've been putting more and more information on the website over the last couple months. And so this is a clip from the Department of Labor and Industry's website on some of the frequently asked questions and the topics that they're addressing, whether just giving employers basic information, answering some of the general questions, and addressing how employees earn hours for ESST, how they can use it. They're addressing the rates of pay, as well as record keeping and notice requirements to employees. And then, as I mentioned before, the Department of Labor and Industry has published some documents that would certainly be helpful for you as employers. And one is, you can see that the employee notice, the document where you need to notify employees of their rights to use earned safe and sick time. They have come up with a model notice. is both in a Word document as well as in a PDF. And certainly that is a good starting point for you to use to get those notices out to employees by January 1st. It's clearly going to have to be amended by you to specifically address your unique paid time off or vacation or sick time policies and how they comply with the ESST. And then the other thing I wanted to make note of is they also have the workplace poster that is published now as well. And so you can find that poster on the Department of Labor and Industry's website and print that out and make sure that you're posting that by January 1st as well. Just a reminder for those of you that are on the webinar, feel free to ask questions through the Q&A box as we go along. Certainly, I'll try to leave some time here at the end too to address any of your questions. So that is essentially what I had planned to discuss on the earned safe and sick time. I know that there's going to be probably questions at the end that we can address on that. Didn't see any in the Q&A box. So a couple other things just to be aware of. Effective January 1st of next year, employers will be prohibited from inquiring into, considering, or requiring applicants to disclose their pay history. In essence, what that means is if you have employment applications, those employment applications should be revised to remove the boxes that require the employees to disclose their pay history. So you're going to want to make sure that you update that by January 1st. Now, keep in mind that the law does not prevent applicants from voluntarily disclosing their pay history to you. So if they disclose it, you're not doing anything wrong. And of course, nothing under this law will prohibit you from asking an applicant what their salary expectations are. And so you could certainly have that put onto your employment applications for the applicants to provide that information. And it's certainly something that you could ask during an interview. And then just a real quick note, this is not a big item, but there is another new poster that comes out that takes effect as of January 1st. And employers are going to have to post the notice with regard to veteran benefits and services. And that poster is going to have a minimum amount of information regarding the benefits and services that are available for veterans. I haven't seen that Dolly has come out with this model poster yet. They may have, I just haven't seen it. And so you might want to just take a quick look there to see if it's been posted, but certainly something to keep in mind that you're going to need to get that posted by January 1st. And then the final topics that I wanted to touch base on relate to the nursing mothers, the parental leave, and the sick leave. And this is more as a reminder for those of you that are participating in today's webinar, and that is there were some changes that took effect July 1st. And I'm still seeing clients that they haven't updated their employee handbooks to address some of these issues or weren't familiar with the changes. So just to touch base on them. First, as effective as of July 1st, there were changes to Minnesota law that deal with accommodating nursing mothers, lactating employees, as well as pregnancy. And these changes took effect as of July 1st. They impact all employers in the state of Minnesota. And there's a couple things that you need to be aware of. One is we now have notice requirements that employers must notify employees of their pregnancy and lactation accommodation rights at the time of hire and when the employee asks about or requests parental leave. The Department of Labor and Industry has published a model notice that you can use, but that's something that you're going to want to include in your onboarding documents with employees, and also just be familiar with the fact that you have to provide this notice at the time the employee asks about parental leave. also, as you're updating your handbooks, and I know a lot of folks have waited until the end of the year to update their handbook for next year, but keep in mind that as you update your handbook, it needs to include a notice of these rights in the handbook. And again, as I said, Dolly has published the required notice that you can use to incorporate into your handbook. With regard to pregnancy accommodations, there's been some amendments to state law, and some of them were pre-existing, some of them are new, but just keep in mind that under Minnesota law, pregnant employees are not required to obtain a doctor's note, and employers can no longer claim undue hardship for pregnancy accommodations related to more frequent or longer restroom, food, or water breaks, the need to sit, or the inability to lift over 20 pounds. And in addition, under the law, reasonable accommodation may include a temporary leave of absence, so the employee needs to take a couple weeks off, or it could be that they need to take or need to modify their work schedule or get new job assignments, and those are considered reasonable accommodations. And so if an employee takes time off, they take a temporary leave of absence as a result of a pregnancy accommodation, they have a right to return to their previous position or return to a comparable position with similar duties, the same or similar number of hours and pay. There were changes to the law as it relates to accommodating lactating employees. Again, some of these were pre-existing requirements, some of them are new, but essentially employers need to provide reasonable breaks for employees to express milk. There's no time limit on providing those breaks, and the breaks can continue beyond the first 12 months after childbirth, and that was a change. The prior law, you could limit the breaks to taking place during the first 12 months. And then it goes without saying that you have a requirement to provide employees with a lactation space, and that space needs to be clean, private, secure, and close to the work area where the employee is working. And then, as I said before, this is the parental leave, the school leave, and the sick leave are changes that took effect July 1st, but I still see some clients that weren't aware of these changes. And so here's a couple of the changes just to keep in mind, that when we're talking about employees taking time off for parental leave or school leave or sick leave, it applies to all employers, regardless of how many employees they have. So previously, prior to July 1st, it only applied to employers with 21 or more employees. And then the second change, which is a notable change, is parental leave, school leave, and sick leave apply to all employees, regardless of how long they've worked for you. So under the previous law, employees had to work for you for at least 12 months and be at least 1/2 of a full-time equivalent to take advantage of parental leave or school leave. And now it's all employees, no matter how long they've worked for you. So what that means is, from a parental leave standpoint, all employers must provide employees with an unpaid leave of absence of up to 12 weeks for the birth or adoption of a child, or for prenatal care or incapacity due to pregnancy, childbirth, or related health conditions. And then second, all employers must grant employees, no matter how long they've worked for you, with school leave of up to 16 hours during a 12-month period of time, so that the employee can attend school conferences or school-related activities. The third issue related to sick leave benefits, I'm going to skip over this bullet point because in essence, effective January 1st, the sick leave benefit portion of state law will no longer apply. But essentially what that law provided is, if you provided sick leave benefits to employees, so you had a sick leave bank, you had to allow employees to use that sick leave not only for themselves, but also for an employee's child, the employee's adult child, spouse, siblings, and what have you. But that provision of the law will go away with the adoption of the Earned Safe and Sick Time law that takes effect January 1st of next year. And then finally, I know a lot of people are concerned about how paid family medical leave will be implemented. The only good news that I can provide you right now is we're still 2 years away. So the law doesn't take effect until January 1st. It's going to be applicable to all employers, and it will cover all employees provided they've worked for you for at least 90 days of employment. The funding, I think all of you are aware, the funding is such that employers will have to fund at least half of the premium cost through a payroll tax. Now, one thing I'll mention to you just to keep your eye on is there are insurance carriers that are coming up with a private insurance product that will meet the requirements of the paid FMLA. And so states that have adopted paid FMLA, and Minnesota included, have allowed employers to have a private insurance product that meets the state law. And so these insurance carriers are coming up with a product that may be something that you want to consider adopting in lieu of the payroll tax. But again, we're still 2 years away with regard to how that will play out. But you may want to have the insurance carrier administering the paid FMLA versus having the state. I know that was a lot of information in a short period of time. As I mentioned, I would keep some time open for questions. And so I'll turn it over for questions at this point. All right, looks like we have one question here. Yeah, common question. Will we have access to the slides from this presentation? And absolutely, I'll make sure that they are available to you, and I'll get them to Chris, and Chris can distribute them. Any other questions?
You can also, the recording of this webinar will also be provided along with the slides. So Tom will give us the slides and we will send the recording too.
Yeah. Someone asked the question, how do you handle employees that are 100% commission? And that is a great question. I wish I had the answer for you. We're waiting for the state to provide employers with guidance on how that will be handled. I know that there are, if you fall under some of the municipalities that have an earned safe and sick time, Minneapolis, St. Paul, as examples, I know they have addressed this in their FAQs, but how you will comply under the Minnesota statewide earned safe and sick time, we don't have the guidance yet. So I wish I could give you that answer, but I don't have it right now. Any other questions? All right, another one. If we give employees 4 weeks of paid time off to use at the beginning of the year, do we need to track the 80 hours of sick and the 80 hours of paid time off? And the answer is no. You're not going to have to track what they're using it for. And this becomes an individualized question. But just keep in mind that if your paid time off policy meets or exceeds state law, you will be in compliance with regard to at least the accrual or what you're providing them for. You don't have to actually track what they're using the time for. Certainly haven't seen anything where Dolly has taken that position, but they would be able to use it for earned safe and sick time, and you're going to want to make sure that your policy is drafted such that they know that they can use the paid time off for the reasons allowed under the earned safe and sick time. Another great question, how employers will enforce an attendance policy for hourly employees. And so the question is, if they call in sick and say it's ESST, it's excused. And the answer is yes, it's going to be excused. And the other comment is they can use the earned safe and sick time in the smallest increments that the payroll system allows them to do. So even a 5-minute late tardy, the question is, could it be excused if they say ESST? And potentially it could be. So as an example, the employee takes somebody, it says they took somebody to the doctor's office, and as a result of going to the doctor's office, they were late, but they were late by 5 minutes. I think they could say, yeah, that 5 minutes was being used for earned safe and sick time. And so the question is this going to render attendance policies essentially useless? And I understand the question, and I think certainly the risks are going to be much more significant if you have a point system for somebody who, with the earned safe and sick time law coming into existence. Because like I said before, you're going to want to make absolutely certain that the person who is taking time off is not taking time off for a reason that's protected under the earned safe and sick time. Because if you're not certain and you take action against them, you've opened yourself up for a potential claim under this new state law. So I agree with the participant's question, doesn't that create problems with an attendance point system? And I think it does. Another question that's come up is, if we provide 80 hours paid time off and the employee uses that for vacation, do we need to accommodate any additional time for earned paid sick time after the 80 hours have been used? And so I think the question really is coming down to, first, I'm assuming that your paid time off policy has been revised such that employees can use the paid time off for any of the reasons allowed under earned safe and sick time. Once they've exhausted their rights for earned safe and sick time, uh, they won't have a new bucket for the earned safe and sick time. But I think what you have to be careful with, and you have to keep in mind, is there may be other reasons why they can take unpaid time off that is protected, whether it's under the Family Medical Leave Act, whether it's under parental leave, under state law, or what have you. But certainly you're not going to have to provide them with additional paid time off. Another question is, we put a cap on PTO hours rolled over to the next year. Does minimum rollover need to be at least 48 or 80 hours? And the rollover is they're allowed to roll over up to 80 hours, but they can't accrue more than 80 hours at any given time. Now, in that first year, if you're just providing earned safe and sick time, the most you're going to be able to roll over would be 48, right? Because that's what they accrue, assuming that you're just allowing accrual of 1 hour of every 1 hour for every 30 hours up to 48 hours. But the law is you have to allow them to carry over up to 80 hours, but they can't have, you don't have to allow them to have more than 80 hours in their bank at any given time. And also, I know it gets a little confusing when you start talking about rollover and front loading. And what I'd suggest is as you're trying to figure out what makes the most sense for your policy, reach out to counsel who can guide you on that. Obviously, as I said before, the Department of Labor and Industry has also published a lot of frequently asked questions, and they're addressing the rollover question in a number of their frequently asked questions. And sometimes it's easier to have that in writing as you're trying to think through it. And so, like I said, the department's website is a good start. When I read their what they put on their website, I think they're pretty fair with regard to how the law should be administered. So hopefully that answers the question. I know there's another question on front loading with no payout. And again, I'm gonna refer you back to with regard to the carryover and the front loading. The slides will be available, and the Department of Labor's and Industries frequently asked questions will address some of the questions on carryover versus front loading. So I'm going to defer that question for now. Another question is raised if new employees earn 80 hours of paid time off for the first year, if they use that 80 hours for vacation, do his employers have to provide the employee with additional 48 hours of earned safe and sick time? And again, this is going to come down to how you draft your policy. But keep in mind that as long as your policy is drafted such that you're providing them with paid time off that meets or exceeds the reasons set forth under the state law, you do not have to grant them more time. So for the question that was asked, if you're providing the new employee with 80 hours of paid time off in their first year, and they decide that they're going to use that 80 hours for vacation, they don't get an additional 48 hours of earned safe and sick time, again, provided that your policy is properly drafted. And again, keep in mind that even though you may not have to offer them paid earned safe and sick time, they may be entitled to time off as a result of another statutory protection. Like I said earlier, maybe it's wouldn't be the FMLA, but it could be parental leave, or it could be a leave of absence as an accommodation under state or federal law. Any other questions?
It doesn't look that way, Tom.
All right.
I want to thank everyone for participating today, and thank you, Tom, for some great information that I think will be used. Go ahead, you can say goodbye now too.
Oh, yeah. Thank you for your time, and certainly feel free to reach out if you have any questions. If you tell me that you participated in this webinar, I can answer the question as initial courtesy for you as well. My contact information is on this slide, and as I said earlier, I'll make sure that Chris gets a copy of these slides so she can distribute it to the webinar attendees. So thank you very much for your time today.
Thank you, everyone. Have a great day.